In a class I taught today, someone asked me why certain title companies require the signature of both a buyer and seller on a release of contract when the buyer terminates under the option period. Some title companies don't require both signatures. Well, I can't speak for other title companies, but Allegiance Title requires 4 things to be evidenced in our file before we can release the earnest money under an option period termination without requiring the signature of the seller. First, the effective date of the contract must be in the contract. You'd be surprised how many times it isn't. 2, we have to have evidence that the seller received the option check within the time required. Third, we must be provided a copy of the written termination and evidence that it was sent within the time required under paragraph 23. And finally, we must have evidence as to how or where the notice of termination was delivered. If the notice of termination is delivered to any place or address other than that shown in paragraph 21 of the contract, there is a question of whether there was timely delivery. Without the evidence of all 4 things in our file, Allegiance will require a release of contract to be signed by all parties. Next time a title company requires a release of contract signed by both parties, when the buyer exercises his right to terminate under the option, look to see if you have provided all the evidence of the valid termination. If not, you know why the title company requires the release. If you have, ask the title company why they require the release. It may not be needed. But every title company has the right to establish their own policies and procedures to be followed to assure that it meets its fiduciary duties to the parties. I hope this video sheds light on some questions you may have had. Allegiance Title wants to serve you as you serve your clients. Thank you for watching, and thank you for your business.